Good afternoon. Now, Mr. Connell?
Right, Mr. Hall, arising from one of your answers, we've been doing some digging, and that was over the definition of clinical functionality in the contract. So I'm going to ask that bundle 17, page 735 is brought up, which with a bit of luck will it's a slightly, yeah. Now that I'm told is an extract from something marked Appendix 1 within Appendix 5 within the multiplex design and build main contract, which appears to set out a definition of clinical functionality, points of access, relationship between buildings. Well, leave these aside because these are bigger picture issues for the moment. Size of rooms, location and relationship of equipment, furniture, fittings, etc. Interrelationship between rooms, fire strategy and infection control only insofar as these relate to clinical use. Now, do you think that's what you were suggesting?
Yes.
Thank you very much. You'll appreciate that part of my reason for doing that is that also allows everybody else in the room to know exactly where they can find this if they want to go and look at it over the weekend. Can I ask you another question? And it's largely, it's not on this document. Thank you very much. It's largely to make sure that I'm understanding as clearly as I can one of the points you make, because one of the pieces of evidence you give us today is that you say, well, yes, this was all agreed ultimately in the last few days before contract signature over the ventilation derogation, but there was scope for that to be reviewed, notwithstanding it was in the contract, and that could be done in the next year. Am I right in understanding? You may have told me some or all of this, but please bear with me, that one of the possible consequences of a change of approach, were it to be done in the next year, is a compensation event, which might involve payment by the board to the contractor for the consequences of the change. Is that correct?
Yes.
And as at December 2009, it might have been difficult to estimate what that consequence might be in money terms.
Agreed.
Thank you very much. Now, I think I've probably got a reasonably clear picture of your involvement or otherwise in the ventilation derogation discussion, but I'd just like to come back to who knew what when, because as you probably gather, this has troubled both the board and the inquiry because we haven't found convenient records. You're asked at paragraph 96 on page 224 of your witness statement. The phrase there is, how was it signed off by the board? And you referred to some comments in response to a PPP, which is arguably not a very fair question. But what you say there is that you were aware at that time, so presumably way back in December 2009, that Alan Seaborn and Peter Moyer had advised Helen Byrne, Alex McIntyre and Peter Gallagher of the agreed ventilation derogation. Can you help us at all as to why you know that?
It would have been via conversation.
Did you have any understanding at that time about any of the governance structures that the board had put in place to look after the project, different committees and so on?
I understand that there was a board that sat in relation to this project.
Have you any knowledge as to whether this matter was reported to that board that you?
Personally, no.
Thank you. Moving on to another topic, because your witness statement then on 225 moves on to another chapter in perfectly logically ordered chronology. Can I ask you one question, because it came up with another witness and I'd like to make sure I understand your position. As you can probably gather, there has been a discussion about how the ventilation derogation was recorded, what you can gain from that, what you can understand, what you can't. We've done that. I won't ask you about it again. Would you agree that in general terms, that were there to be any derogation from a guidance document such as SHTM 0301, just for convenience, during either design or construction, then there should be a record of what it was, why it was, who agreed it, what it applies to, and so forth.
Do you mean within the contract, or do you mean within?
Now, as a matter of general principle, would that be a desirable thing to have?
Well, in terms of the way that sort of thing, it would have been addressed via the early warning process and recorded through the actions of the contract.
The part of the reason I ask that is that one possibility is that somewhere in the preparation of M&E design, not the user group stuff, M&E design, someone may have designed something which does not provide SHTM 0301 compliance, and perhaps somebody has signed that off in some way. And therefore you can ultimately track back. If you go through all the documents, you can eventually work it out where it came from, but there's no clear record at the time. So I was just wondering whether you had agreed as a project manager that in principle there should be a clear record somewhere.
I think there is a record within the contract documentation, because there are different levels of sign-off, and there are instructions going to other parties. So, for example, I'll take an example. Some of the drawings relating to ventilation were reviewed by Capita, because Capita received an additional instruction from the board to undertake some design reviews, and that was the typical process that occurred within the recording of any derogation, if we use that word. That was the process that was followed. Multiplex notified, Peter Moyer instructed Capita in those instances to undertake that review, and that review was then resulted in a sign-off by Capita of the drawings.
Again, Mr. Hall, you do speak quite quickly.
Sorry, apologies.
I'm not asking you to speak at dictation speed, but I am trying to take a note of what you're saying.
Yeah, I think what Mr. Hall has just said is that one example of a recording of a departure from an SHTM might be if a proposal was made for such a departure, that Mr. Moyer then instructed Capita on a specific instruction to review this proposed departure, and there was then a signature on a drawing, perhaps, recording what had been reviewed. I think that's the process the witness had just
That's correct.
explained. I suppose my question to you is, if you were looking at the contract documentation, trying to find out how it came to be that room X was built with the wrong air changes, just say for the sake of what appeared to be the wrong air changes, it might be quite difficult to actually find that if there is no record kept. That's what I'm getting at.
Yeah.
Do you agree?
In retrospect, a fair point.
You mentioned early warnings, and I'd just like to make sure we understand what these are. In your witness statement at 225, you set out various responsibilities that became the board's after the contract was let. You got 225? Yeah. And there's a list there, and I needn't go into that. The last thing we want to talk about is time and cost management. So 98.6, early warning. Now, first of all, so his lordship understands, what's that mean?
I always think it's wrongly named. The NEC contract is a collaborative framework. I think it should actually say early notification, but formally in the contract it's called an early warning. When the contractor is aware of something that is arising that could potentially impact upon the cost or time or specification of a project, they have to raise an early warning. Early warning can be raised by either party, so the client or the project manager can also raise an early warning where he has observed something or he requires a change. So there might be a scope change required by one department to bring in a new piece of equipment or something. An early warning would be raised. There would then be a meeting arranged with all interested parties to discuss and discuss what the implications are of that. If it's agreed to go forward, you would then request a quotation from the contractor for the alteration works, and then it would be accepted with the impacts of time, cost, etc. noted.
Yeah, so this is not dissimilar to the kind of notifications that you're required to make in other standard forms of building contract when you think something else needs done and you think you might want paid for it.
Yeah, I mean, it's. I think the important word under NEC is the early, because it's meant to be you are forced by the contract to notify within a maximum of 8 weeks of becoming aware of an issue, and this avoids the perennial problem with other forms of contracts of a big bun fight at the end of the project.
Did you get involved in early warning meetings?
Yes.
And did you get involved in providing technical advice in the course of these meetings?
Only contractual or program related.
I wonder if we could look at bundle 32, page 59, please. This is just trying to continue to understand your role, Mr. Hall. Let me see. In para 7010, which you see on the left hand side, there's a discussion there. DS reviewing comments received back from C&B. Now, do you know what that's about? August 2010?
Yeah, that would almost inevitably be the comments from Wallace Whittle. Because that would have related. It said M&E process underway, boards start sign off drawings, M&E workshops very beneficial. So that appears to be tied to the above comment, and I would suggest that whilst it came from C&B, it was obviously under the auspices that Wallace Whittle had prepared that.
Can we look at page 163? No, 16. Thank you. Now, you get involved in discussing drawings about changes here. I see there's an item involving you at 12th of April 2012, and then also 29th November 2012, and in other places. You seem to have a pretty major role in these discussions.
A lot of them. I mean, I noticed the first item refers to programme. We'll update on programme for return. So a lot of my work was around programme. Yes, I was coordinating the return of these. I wasn't necessarily reviewing all of these documents personally. There's one down there on the 13th of December referring that I would liaise with Francis Rath for are you returning the documents. So in much the way as we spoke before, I was almost like the coordinating point in many of these cases.
Okay, thank you. And 173, please. Same bundle? No, let's see if I can find the right version. I had a note that you had been preparing a sketch of something to do with the MTHW system, a proposal which ultimately didn't proceed. And I was wondering why somebody in your position was preparing a sketch on that.
I don't recollect that. Is that in there somewhere?
No, I'm not finding it in there. So we'll move
Sounds
on.
odd. Doesn't sound like something I would have been involved in, but
Okay. Cool. Now, the next, we can leave that document, thank you. The next part of your statement narrates various groups that you were a member of, and then we go on to the RDD process, which to some extent we've already touched on at various points of our earlier discussion. A lot of the evidence that we've had about this, Mr. Hall, splits the process into two. The first bit being user group sessions. And for instance, I think Mr. Pike told us, was that only yesterday? I can't remember now, that there were no air change rates visible on anything that the user groups were shown, which is perhaps understandable if they were looking only at clinical functionality. You participated in a lot of these, is that right?
yeah, obviously, yeah, a significant number, predominantly again in the adult hospital,
Right.
critical care, theatres, and the likes.
The other part of the RDD process that is said to exist are what were thought to be M&E design meetings. So user group meetings to discuss clinical functionality, and then M&E meetings to discuss M&E design. Now, is that how you recollect it?
I think what I would say is that you look at the responsibility, the activities in the user group, and where we're looking at clinical functionality, there is almost a two-way conversation for the designers to understand the needs and everything else. If we're looking at the M&E is predominantly set out by the SHTMs and the guidance and everything else. So in effect, what is happening is that Multiplex are designing in accordance with all of the standards. Where they raise a question, they then have a meeting, and then there was presentations on various things, predominantly about operational functionality. So, for example, if we take fire alarms, there would be a presentation on fire alarms, including the cause and effect, and what that would have in terms of implications on how the hospital operated, in terms of how you got people out of the building, etc. So there was less interaction in terms of a two-way about the M&E, because the M&E was set by the standards. The designers were designing to those standards and were then presenting it back.
Right. But thirdly, some witnesses, and of course recollections differ and recollections will fade over time. Some witnesses seem to think there were essentially two sets of meetings, user group meetings, which dealt with where the bed's going and the other practicalities we've discussed, and then M&E design meetings. And then when GGC witnesses were asked, well, who would be in the M&E design meetings then, given that you didn't have an M&E designer? And that's where their knowledge ran out, other than those who suggested that, well, possibly David Hall was there. So the idea of two sets of meetings, one discussing M&E design and one discussing UGMs, is not quite correct, according to you.
Well, what I would suggest is that they had different structures and different styles. So one was a collaborative two-way approach. The stuff on M&E, where the meetings were, there was multiple meetings on different systems. So you would have a meeting on water, at which the designers would present what they were doing. And in that meeting, you might have had Peter Moyer, myself. You would probably have had Ian Powrie in that meeting, and you would have had others that had specialists, more knowledge on water systems from the FM part of the board. You would then have you would have other meetings on fire, and in the fire case, I think we brought in representatives from not Health Protection Scotland, it was the chap from HFS, Health Facilities Scotland, was brought into that, who then gave advice on what we were doing in terms of that. So that there was not, and there was also zonal meetings about how but when I talk about meetings, they were more presentations than meetings, because the board had already given their requirements in the form of all of the employer's requirements.
Now, leaving aside any possibility that some particular proposition came up on which a special instruction was given to Capita, you've explained you weren't supervising Capita and you don't know exactly what they did or didn't do. Was there anyone with M&E engineering and design knowledge participating in these meetings, presentations, whatever you're talking about, for the board?
Beyond 2010, no.
So, well, let me just understand it. I thought these meetings, the RDD process was primarily early 2010 for about a year.
No, our review of design data carried on.
Right.
As the design carried on. They went beyond 2010.
Okay, well, maybe I'm misunderstanding the position. While the user group meetings were going on, were there other discussions about ventilation design going on?
There were presentations on the ventilation design.
And was anybody participating in these presentations from the board's perspective with specialist knowledge in M&E design?
M&E operation, yes. M&E design, no.
Right. Are we, these meetings or presentations, are we talking about the period that comes to an end with the instruction to proceed?
No.
Right.
Goes beyond that.
Going beyond that. So how long?
In theory, design goes on for a very long time through, you're probably talking into 2013 at least.
Right. So the design, at least in certain respects, is a process which is continuing into 2013.
Yes.
And no doubt is running in parallel to the beginning of construction.
Or beyond the beginning of construction, to be honest.
Yes.
I mean, your construction started in 2010, 11,
Right.
and then it must be 2011,
Right.
and you're still designing at that point.
Now, as Mr. Connell has said, some of the evidence would sort of suggest parallel process of user groups, probably discussing clinical functionality and what have been described as technical meetings. Now, you appear to have confirmed to Mr. Connell that there were meetings or were they simply presentations? In other words, the multiplex designer informing GGC representatives on progress.
That's correct.
But it wasn't a matter of, or maybe it was, but was it or was it not an occasion for the GGC representatives feeding into the design or criticizing the design or questioning the design?
Only in terms of operation. So for example, if we were talking about a water system and flushing, there would be somebody from the facilities department, Ian Powrie typically, who would comment on the ability to flush out a system or alternate, that type of thing. So there was an operational element to the feedback, but there was nobody present in the room who could challenge the design. The designer was saying this is in compliance with the guidance, and this is what you're getting.
But essentially, the purpose is just to report on progress.
Yes, because they were managing the design.
So if participants or some participants in the user group sessions thought that somewhere else someone was checking, compliance with SHTM and all the other issues that might go into the design of a ventilation system, that wouldn't really be an accurate description of what representatives of the board were doing at that stage.
The compliance was Multiplex's responsibility.
Because issues have inevitably been raised as to what signing off means. What does it mean when Francis Rath or David Hall sticks their signature on one of these drawings? And you're asked specifically about this, I think, at page 228, just so in fairness to you, you can see what you've said. You say at the foot of there, I've been asked whether it's part of the reviewing design process to ensure the design complied with guidance, and whether this is what I was signing off on. Compliance with guidance was fully the responsibility of Multiplex and the design team, and that is not what you were signing off on. And that's your position, is it?
That is clinical functionality.
And that goes back to the discussion we had earlier about everybody knowing that that's what you were doing. You understood.
Yes.
Again, I'm sorry if I'm being slow on this. When you're talking in paragraph 105 about signing off, that is signing off in the context, and by which I mean, I'm imagining actually during or at the end of a user group meeting. Or is it something else?
So, this, we're signing, right, following user group meetings, other workshops, then revised drawings or drawings would be issued. And then there's a review of the drawing for clinical functionality. And that's what's being signed off, to confirm that the things that have been requested in that meeting have been addressed.
Right. Do we want?
Well, I'm going to try and take this by example, if I can, so we can understand it. Because there's an issue has arisen, Mr. Hall. So let's be quite open about it as to whether people thought there was somebody out there who was checking these things for the board, checking compliance with all the different requirements for the different rooms, for the different wards and so on. And what you're telling me is, no, there wasn't. That was Multiplex's responsibility.
Yes.
Is that correct?
That's what the contract says.
And that is what was happening.
Yes.
Could you explain to me what a workshop is and what its purpose is?
Well, typically in the what I was talking about, it's a presentation by the Multiplex design team of how they have addressed the delivery of air throughout the hospital or delivery of water throughout the hospital. They will be showing where the water tanks are. They will be showing how that is then taken through the system. That was probably more important in those scenarios in terms of maintenance. So Ian Powrie would have sat in that meeting, for example, and looked at how would if that was what the board were getting, how would he maintain that? It was Multiplex's responsibility to deliver a compliant system, but there's also the question of how do you maintain that afterwards? And Ian had to satisfy himself on that situation that he could maintain that system.
Is a workshop the same thing as a presentation, or is it additional to a presentation?
It's probably more of a presentation, to be honest, those ones, because there was no, excluding that operational piece, there was no two-way in it. That was what I was trying to describe at the beginning. The user groups are very much about this is what we want, this is how we, and it's an interactive process. With the M&E systems, the standards were already set by the employer's requirements. Multiplex had to go away and design to those standards, and they presented what they had come up with. But they presented that to a team that, other than in terms of maintenance, wasn't going to comment back on how they had designed the system.
I may be looking for a sort of neatness, which is not realistic. But should I hold on to the notion of the distinction between user groups and technical meetings, whether perhaps better described as
Presentations.
presentations or workshops, at which GGC representatives were present. I mean,
Yes.
right. But the purpose of their attendance was essentially to be informed about what was going on,
Yes.
not to review or check or sign off anything.
Well, in terms of the drawing sign off, all that was being signed off for, as an example, if we take a reflected ceiling plan, all that was being signed off was, is there a light fitting to turn, to turn
Sorry,
on?
is there a
A light fitting?
Right.
Are there lights in the room? Are there, any other pieces? IT? Do we need IT in the room? It was those type of things that might be on the ceiling. Fire alarm, sounder location. Is that in the room? But not how it's delivered, and how it complies. It's purely the visible functional elements to make sure that they're there. That's all, in accordance with the process that was set out in the contract.
And mechanically, sign off would be adding a signature or initials to a drawing.
Yes, that's correct.
Mr. Connell?
Well, let me just divert round a small corner and we'll come back to where we are
Okay.
now. Because you deal with it on the same page of your statement. One of the slightly odd comments that has floated into the exchanges was that Multiplex wouldn't recognise a Capita signature. And people have tried to find out, what's that about? Why did it happen? You have offered an explanation, I think, at the foot of 103 and then on to 104. You say, as far as Multiplex are concerned, they wanted to see one of 3 or 4 names on the drawing, Peter Moyer, Francis Roth, or you.
Yes.
And then you say, well, why didn't they recognise Capita if Capita had been involved in the process, duly instructed? And your understanding was it just because Capita went around when the deal was struck?
That's correct. When the RDD process was set out, Capita were not appointed by the board.
Right.
So at the outset, they were not part of that RDD process. They were added into the RDD process to address, and part of it was because that at a point in time, and I think we're all aware of this, Wallace Whittle bought ZBP. So if the board had returned to Wallace Whittle, they would have created a conflict of interest potentially, and therefore Capita was a more acceptable route to go with those technical clarifications.
And you add a nuance then to the sign-off options. You've talked about signing off following a user group meeting for clinical functionality. And then you mention in 103 the possibility that Capita have been instructed to do some form of review of some kind. That's been completed. Capita are okay with it, but Multiplex won't accept a Capita signature. So you sign off that drawing, is that correct?
Just in addition to the Capita signature. So the
Right.
Capita signature remains on the drawing. Mine is added to note that it has been through the RDD process.
So the function of your signature is simply to say, I'm a project manager, I'm telling you this has been through a
Correct.
process.
Yes.
That's what we can just try looking at 1 or 2 of these just so we understand what we're all talking
Correct.
about. Perhaps we could have bundle 47, volume 3, page 5, please. And this has a signature, which is the usual alert on these situations. Now, this I'm told is the 2A Schiehallion reflected ceiling plan. Have you annotated this? Maybe you can't tell.
That is not my writing. So the annotations on that drawing appear to be annotated by the Brookfield reviewer.
Right.
Or Brookfield Multiplex.
Now, if we remember that 2A was known to be a ward with specialist requirements, the Schiehallion ward, I think the point being put by some is that, well, if you're given something like that, which demonstrates, for instance, the presence of chilled beams, the absence of an airlock, a grid ceiling rather than a plasterboard ceiling, or whatever the point happens to be, if somebody puts their signature to that to say tick, then does that not indicate approval of what is being shown on the plan?
Only for clinical functionality.
Even though you know the purpose of the ward, you know the general.
But I'm not a designer, and I don't. You know, you wouldn't review the design. To have somebody reviewing that design, you would have to engage an equivalent designer.
So nobody that you're aware of looking at something like that would be expected on the board's part to say, what on earth are you doing with Ward 2A? That's not what we were expecting for a ward of that kind.
There was nobody in the team to do that. The responsibility lay with the contractor, as it's a design and build contract.
Well, you know, I have your point about the design and build contract and where contractual responsibility lies, but if we're looking at avoiding problems and avoiding them usually earlier rather than later if we can, then, I mean, to take an example, we've put a drawing like this to others, and we were able to work out that the original intention to have an airlock near the top left of the drawing at the entrance to Ward 2A, which apparently had been mentioned early on, wasn't there. Now, if the circulation of drawings like this kind had to have maximum effect, should somebody not have been available to review that?
The airlock would not have been picked up on a reflected ceiling plan. That would be picked up on the plan.
Right. Okay. Well, take it from me, it wasn't.
Well, if it was to be, that's where it would be picked up.
You see what I'm trying to understand what may have worked and may not have worked, so that we can look at anything that might work better. And what, for instance, what you see in a reflected ceiling plan are the grids and the stuff that's in the ceiling, ventilation units and stuff like that. Now, we know that one of the issues here has been where you should have chilled beams and where you shouldn't. Therefore, if somebody who was familiar with that issue had reviewed a reflected ceiling plan, they'd be able to see that there were chilled beams provided in quite a lot of areas in Ward 2A. And if appropriate, could have said, what you're doing with that in a specialist ventilation area, or why is there no airlock, or other questions. But there was nobody available to GGC to perform that function at that time, is that right?
Correct. Well, there would have been people available, but they weren't appointed to do that.
Yeah, sorry. So I'll just look at one more, just so we can complete this point.
Okay.
Bundle 47, Volume 2, at page 15, please. Now, this I described to another, and this has a signature on it as well. This I described to another witness as looking like a build-yourself doll's house, because you can technically you can sort of fold up the sides to make the room if you were, a child trying to make a model. And again, presumably this is a renal. But if you were looking at that as a specialist or knowledgeable designer, you might be able to say, oh, why isn't there X or Y, or why am I not seeing what I'm expecting, depending on the particular drawing. But this is the process that really wasn't happening wearing a ventilation hat, is that right?
Well, no, the M&E system, I mean, well, again, this drawing doesn't show any ventilation. This is really about equipment.
Yep.
And what goes in the room. So this is, you know, the user group will have reviewed this drawing. It's been through the process. It's met the requirements that they have, and therefore it's been signed off.
Yeah, by you,
Yes.
in this case. I take it that's your signature near the top right hand of this particular page.
Yes.
Thank you. We can take that away. Thanks very much. And you weren't party to what instructions were given by Peter Moyer to Capita to do any particular ventilation reviews, although you may occasionally have been asked to sign something off because you needed an additional signature.
Yes, correct.
And when you were doing that sign off, you didn't yourself make any investigation into what had or hadn't been done.
I may well have spoken to the Capita. I mean, again, Capita were sat in the same room. They were sitting behind me. You know, I would probably have had a conversation with the person at the time they've signed it off. You know, everything okay. But it would be entirely reliant on their review.
Okay. Let's move on. Carbon filters. You're probably aware from your knowledge of the contract that a possible issue of odour, unpleasant odours, had been raised during the initial processes, and a solution, which was to insert carbon filters so that all air entering was filtered, had been proposed. Is that correct?
That's correct.
And you say on page 230 that you were party to discussions about removing them, although it wasn't your decision as such. It was simply that you were party to these discussions.
Yes.
Is this a cost-driven decision?
I don't think it was primarily a cost-driven decision. Obviously, there is a cost impact and an operational impact to the inclusion of carbon filters. They have a high level of resistance to air.
Mm-hmm.
They increase the energy consumption of the hospital. But another primary part of that was that Scottish Water had a duty to carry out improvement works, as I understood it at this time, to their plant to reduce the emissions in terms of odour. So it was.
And what your evidence is that you understood at the time of the decision something had been said about what they were going to do. Is
Yes.
that right? Do you remember what? Because it's a long time ago.
Well, it was to
reduce the odours.
It was to reduce the odour. Yes.
Okay. Were you involved in the specification of what was originally intended to be 4B as a hemato-oncology ward? Were you aware of for instance, the clinical output specification for that ward?
No, I wasn't involved in the clinical output specification for that, no.
Were you aware that it was at that point intended to be what one might describe as a specialist ward as opposed to simply a general ward?
Yeah, I think it was I can't remember if it was the full wing. I think it was something less than the full wing in that instance when it was originally a hemo. Yeah, but yes, I was aware that there was a zone, yes.
And we know subsequently the decision was taken to move the bone marrow transplant unit into 4B and move the hemato-oncology to 4C. Were you party to any discussions about what had to be done to the environment of 4C to fit that cohort?
Sorry, 4C?
What most of the material the inquiry has suggests that 4B was hemato-oncology and 4C was renal.
Yes.
Renal was set up as a general ward. No doubt there are some plumbing issues in a renal ward, but leaving that aside, a general ward.
Understand.
And therefore the environment that was provided to the intended patient of the renal beds was not the protected environment that was intended for the patients in the hemato-oncology ward. Following me?
Yes.
So we're just trying to find out if anyone knows the answer to this, when a decision was taken, hematology are coming out of 4B, that's going to be bone marrow transplant unit. Hematology are going to 4C, formerly renal. We know there's been a discussion about what to do about the environment in 4B to meet the new requirement. We've been trying to find out if anybody knows whether there was a discussion about what was to be done in 4C.
I'm not aware of that.
It-
That particular alteration was led almost entirely by Peter Moyer.
Do you have, can you help us at all on why, if you looked at the materials for 4B as originally planned, you would find reference in at least part of that ward to 40 litres a second as the air provision?
In hemato, that sounds
Yeah.
incorrect.
Well, the only reason I ask it is that the discussion that there is on the ventilation derogation, just to use that phrase again, talks about it applying to general wards, or possibly general wards in the adult hospital, but leave that debate aside for the moment. So you would agree that provision of that air change rate in what was proposed for hemato-oncology would be incorrect?
That would be my assumption, yes.
And would that be the same if one was to find that reference in Ward 2A, the Schiehallion unit?
Yes.
And was that, maybe you can help us or maybe you can't, do you think that would have been clear at the time of the ventilation derogation, that these specialist wards were not to be affected by the derogation?
I would have thought that was fundamentally clear because, in my view, the derogation only applied to rooms that had six air changes per hour. And I don't think either of the locations you're referring to would ever have had 6 air changes per hour. They should have been higher than that.
Thank you. One of the issues we have in trying to work out who did what when and what they knew when they did things is that once you've done your design process, there are then possibly shop drawings and various other things, but you end up with construction drawings. And we heard, for instance, from Mr. Fernie yesterday that as a construction manager, he worked to the construction drawings. He did not go behind that and think, am I building a Schiehallion ward correctly? He just takes the drawings and he just assumes that that is something that's been agreed by someone else. Was that an issue that would also arise for anybody checking? Mr. Fernie seemed to think, for instance, if someone was checking what that ward was providing in terms, for instance, of air changes, they would simply work off the drawing, the construction drawing. They would not go back to any earlier material, such as design material.
It would depend upon the appointment and at what point people were appointed and were reviewing in terms of, I think you're referring to the supervisor role.
Yes.
And you would need to look at the appointment and see what the appointment said in terms of that, because the supervisor role under an NEC contract can be slightly different depending on, one, when the supervisor is appointed, and secondly, what their overall duties are.
Can you help us with this and tell us if you can't? When Capita were instructed to do something other than their standard supervisor role, but to do review of some ventilation issue, do you know who was doing it from Capita?
It would depend on what they were reviewing, because obviously Capita had they were a multidisciplinary practice. So it would depend on whether it was an architectural issue, which would be John Redmond. I think in the case of the ventilation ones, it was a chap by the name of Alan Follett. And I think you'll find that it's probably Alan Follett's signature. I think I saw it in one of the documents that was referred. So Alan was from Capita, and he was reviewing the mechanical. They also had somebody doing electrical and other things as well. So it would depend on what the focus of the question was as to which of their team would review.
One of the questions which kind of follows through from that is that if you then go on and build whatever you're going to build, there comes a point where you need to commission the ventilation system. And the indications we had from Mr. Fernie were that not only what his team would do to commission, to arrange for commissioning, but also any check on that commissioning that was done, for instance, by Capita, would be based on the construction drawings rather than on guidance or anything else. Can you comment on that at all?
I think that's probably the difference between commissioning and validation. Commissioning would check that what was built was what was designed.
Sorry, say that again. Commissioning would check
That what was built,
what was built,
what was built was as per the design.
but you wouldn't know that unless you went back from
No,
the
no.
construction drawings. You'd
The
simply.
construction drawings are the design.
Right.
So the design is what they would check against.
So that if somebody was trying to check, let's say this room was supposed to be designed according to guidance with 10 air changes, just for the sake of argument. That wouldn't be done at the commissioning stage because somebody would simply look at the construction drawing and see what it says. And if it said something different, they would simply accept that.
Correct.
So they wouldn't actually know whether it was compliant with the employer's requirements or not. Is that right?
That's my understanding. Yes.
Yeah.
I wasn't, as I said in my own statement, I wasn't directly involved with this.
No, and that, as you point out, is why there's the provision for validation in the guidance, because then somebody else comes along and says, well, you may have commissioned it and worked out that the air handling unit is working, but is it doing what I, as the client, want it to do?
Yeah.
And that's validation. Should that have been built into the construction program, do you think, validation?
Interesting point, because it's been discussed at great length on numerous projects. Big part of the problem is obviously that there is a lot of activity that occurs post-completion in terms of installation of equipment, installation of beds, all sorts of things that come in that impact upon the ventilation. So in terms of that validation, the validation is, as my understanding of the contract, was the responsibility of NHS Greater Glasgow and St Clyde, the board, and the decision was taken, as I understand it, not to include it in the contract pre-completion, but to do it post, related to the level of disruption and everything else that was going on in the hospital in the period from January through to April.
Do you understand there was a specific discussion about doing it, but doing it at a particular time?
Well, I think it was excluded from the programme, and that's going a way back. So if you'd had to put validation into the programme, you would have had to have done extended the programme. So validation was not included within the construction programme. There's a couple of couple of reasons for that. One is obviously that as I've said, there's a lot of equipment to go in. The other part of the problem is if you pay a contractor to stand around for 3 months whilst that's occurring, there is a cost in that.
So in answer to Mr. Connell's question, and it's just, I may have not heard what you said, there was a discussion at some stage to
I can't confirm
not
it.
include provision for validation in the programme, understanding the programme to be the period during which Brookfield was on site. Have I got that?
Well, I don't think it's as specific as a discussion. The validation period was not included within the works for multiplex.
Right. I understand the reasons why it might not have been, but you do see there's a distinction between there being reasons and reasons being discussed.
Right. I know the reasons. I could not recall a discussion on it.
Right. Okay.
I'm simply asking because one of the issues here is that validation wasn't carried out. And in the guidance, even at that time, the indication was that the purpose of validation was to see whether the room or the ward or the area was acceptable. And logically, the time to do that is when you're asked to accept it, which is at practical completion or thereabouts. Would you agree?
Well, as I said, there's the issue about equipment and how accurate the end of validation is, and I think you're saying from a perspective. I don't know if you're doing that from a perspective of commerciality, but there is a significant defects liability period on the hospital anyway for rectification of defects. So had it been discovered, the liability would have sat with Multiplex to rectify.
Yeah, the question may come to be what is meant by acceptance or acceptability, because on one view, if you do validation for a room and it doesn't meet what you need, you don't accept it. You say, no, I'm not taking that room from you, Mr. Contractor, until you fixed it. You see, would that be a logical way of approaching it?
That's one way of approaching it. The other is to address it under the defects liability.
In fact, we have one piece of evidence, maybe, I don't know whether you can comment on it or not, which suggests that you actually never get in practice a failed validation, because what actually happens is the validator doesn't produce a 50-page report saying, here are all the things I find. What he says is he tells the contractor that your air conditioning unit on room such and such is not working, or your duct is the wrong size, or whatever it is, and they fix it. And then he checks it again until you eventually produce an approval. But it clearly seems to be an important process. So we're trying to work out how best to fit it in to the system. Do you have any advice that you could offer as to how best you would place validation in the contract process in a project like this?
Certainly, quite obviously, prior to patient occupation, and giving a period, at a point early enough that you can address issues. But I would still caution doing it too early in terms of all the equipment installation and the impact that might have on all that, on the results.
Can I ask you about an entirely different topic, which the inquiry has had large tranches of evidence about, which is something called Horn taps with an E, thermostatic mixer valve, whatever taps. You have some knowledge about that, is that correct?
That's correct.
And just so you have it in front of you, if you need it, page 237 of your witness statement. And you say at the time of selection, so that was, I think I may be right in saying 2012 or thereabouts.
Thereabouts, yes.
You were part of what's described as a focus group on tap selection because some issues had arisen around infection control and ease of access to filters. And you're aware of advice being sought. It's been suggested that you may have, at that point, added your tuppence worth, which is, why don't we bring in HFS to look at this, or HPS?
The reference was to HPS. I don't recollect it, and I think it unlikely. If I had been asked at that point to bring anyone in, it would have been HFS.
Yeah, HFS. Well,
No, but the reference was to HPS, so I don't think the reference was correct. I don't recollect that discussion because prior to working at the hospital, I had worked with David Browning at NHS Lanarkshire. I was well aware that David had had issues with taps and all the rest in the past, and as was Alan Seaborn. So there is reference in there to discussions with David Browning on this, and David reaffirmed to Alan that he was supportive of the Horn tap at that point in time, having done other reviews. From my perspective, I attended the presentation, and in terms of a logic around ease of maintenance, the Horn tap seemed to be much more easily maintained because all of the components that needed to be maintained were actually in the body of the tap rather than hidden behind panelling, which was the case with many of the other taps. So there was a logic to it, but again, not technically qualified, but certainly from a pure logical perspective, it seemed to stack up.
Now, there were two stages of the Horn Tap discussion. There was the one in 2012, and then there was another one in 2014, which involved a variety of people, including HPS. Do I understand your evidence to be that no one from Curry and Brown was there, but you knew it was going on?
I was aware that people were talking about the issue. I was aware that there was a meeting, but I was not at the meeting, and nor was anybody else from Curry and Brown.
I suppose that you've narrated your understanding of the result, which was that as we've already got them, we're keeping them. I think it may be suggested that, certainly has been to other witnesses, that in reality the decision was not a simple one to say, well, okay, we hear all this stuff, but we're just going to carry on and use the taps. It was to put in place a particular maintenance regime which would allow them to be thermally disinfected. Were you aware of that?
No, I wouldn't have been, in the sense that my interest would have been in terms of, was there an action that had to be taken against the contract in terms of replacement of those taps or anything like that, which ultimately probably we would have had to be instructed if that was the case. The news that came back to me was that they didn't require to be replaced, and as far as I was concerned, from that perspective, that closed my involvement in that.
One of the issues that was picked up after the hospital opened was that the water system had been filled, it would appear, some time before opening, and not the day before, considerable period of time before opening. Have you any thing you can offer to assist the inquiry on when that was done?
I wasn't involved, as you know, in terms of the commissioning of the system. So in terms of precise dates, no, I wouldn't know. I know it was over a period of time because it had to be done in a staged manner. And I was aware from discussions around programme and things like that. As I say, again, I was involved in the programme. So, the commissioning of systems was marked on a programme. So other than that, I had no real awareness of it. The only other thing that came to my attention at a point in time was the water tank support system, which had to be amended.
Sorry, I didn't follow that. Support system?
Sorry, the tanks for storing water in the hospital, not surprisingly, are extremely large. So they're sectional tanks, and there was supports within the tank to hold the lid up, and those were originally hollow.
Yes.
There was then raised a question mark over the potential for contamination as a
Yes.
result of stagnant water, and those supports were replaced. So that came out of, I think, a notification centrally from Health Facilities Scotland in terms of a national observation. It became aware that we had this type of tank, and then there was an instruction to Multiplex to replace the supports within that.
Now, you're being asked about timing. On the replacement of the hollow supports, can you give any indication of when that happened?
From memory, it was prior to opening, around about December 2014.
2014.
Yes.
Going back to the when the filling may have occurred, you said you were not involved. You knew it was a staged process and therefore it would take a period of time. Can you help us at all with the timing of that?
I'm thinking in the region, and again, it'd be months rather than weeks.
Right. So months before January 2015.
Yes.
Thank you.
Do you have any recollection of discussing the filling and raising the issue of concern over the infection prevention control issues that might arise from putting water into a system of that kind?
I remember Ian Powrie talking to Multiplex about it in terms of flushing and the likes.
Now, we know that your firm wasn't involved in the formal inspections of systems for handover, because that was done by others. One of the topics that has arisen relates to the intended planned maintenance system for the hospital and the different components that would be need to be available for that to be done, which would be asset tagging. Then there's an information system called Zutec, and then you need something else. You need a computer-assisted facilities management system. I've had some evidence suggesting that you were involved in discussions about what should be provided and when. Do you have any recollection of that?
Well, yes, I have recollection of it. I have recollection of it being raised at team meetings. I remember Ian Powrie talking to me about it, and but unfortunately, well, not unfortunately, the fact of the matter was I had no access to any of those systems. Zutec required a license to view. I wasn't given a license. It wasn't deemed part of my role. So I had no means of directly checking anything in terms of that system. However, I am aware that it was a point of discussion in team meetings with Ian Powrie, Peter Moyer, and the likes.
The inference, certainly from Mary Ann Kane's evidence, was that Curry and Brown were involved in discussions on these topics and inevitably sided with whatever Multiplex said, rather than whatever estates or someone said. Can you help us at all on that?
Can you give me a date on that?
Well, this would be after it was discovered that occupation, of course, that there was no asset tagging on.
Right. So this was probably after I left Curry and Brown. So in answer, I'm probably not able to help you on that one.
So your involvement ceased in what, May 2015?
Well, I moved away from the project in May 2015. As I said, I was called back on a number of occasions up until August, September 2015. And I left Curry and Brown in February 2016. So anything that occurred effectively after September 2015, I probably can't give any input to.
Okay. And I think the only other thing you deal with in your witness statement is that there seems to have been a meeting in June 2015 where for some reason you were noted as being from the board's commissioning team, or words to that effect. And
I think that's a misnomer.
You say you weren't from that team.
No.
And by that time, as I understand it from 245, you say you were actually away from the project, but may have come back to help out at a meeting.
Yeah, I suspect in that occasion it was something like Peter Moyer was probably unavailable. I was asked to attend, and I do. Whilst I cannot recollect that specific meeting, I do remember that there was a follow-up meeting mid-July with David Loudon, Robert Calderwood, Jonathan Best, and others to discuss issues around that particular issue.
Well, I have currently no further questions for this witness, but perhaps this might be an appropriate point to have a short pause.
Mr. Hall, we need to find out if there's any more questions in the room, as it were. Yeah. So can I ask you to go back to the witness room for maybe 10 minutes or something? Mr. Connell?
I simply have one short clarification question, Lord.
Perhaps just one question more. Mr. Connell?
It's a question that you may have answered, but we're just wanting to check that we understand it correctly. Ward 2A, Schiehallion Ward, I asked you about air change rates and whether the derogation would apply to it, and you said no, because that was a specialist area. I'm just wondering in terms of process, because you're obviously reasonably familiar with the processes that were gone through during the design and construction. If you looked at the room data sheet for 2A, which I can bring up on screen if you want.
Yeah, because it wasn't something, as I say, I was involved in, but if you bring it up, yep.
Okay, well, let's bring it up. Bundle 47, volume 3, page 393. I'm told you can find there a reference to 40 litres a second. Yeah,
Yes,
here we
I
are.
can see that.
Yeah. So you've got extract AC air, supply AC air, both left blank, and then notes, supply air rate at 40 litres a second. Can you assist the inquiry at all into how it would come to be that that was in the room data sheet for a non-isolation room on Ward 2A?
In my view, that's an error.
And who would be responsible for the error, or who would make that error? Do you know?
I would suggest it's ZBP.
I have nothing further, my lord.
Mr. Hall, that is now the end of your evidence, and that means you're free to go. But before you do go, can I say thank you for the work that went into preparing your statement, and thank you for your attendance today. It's been very helpful, and I appreciate that. So thank you very much, but you're free to go.
Thank you, my lord.
Now, we're not sitting tomorrow, and we're not sitting on Monday, as I understand.
That's correct, my lord. We resume on Tuesday with Mr. Pardee, followed by Mr. McKechnie.
Right.
And CPs have also been advised that we now have made arrangements for Mr. O'Donovan of Mercury to give remote evidence first thing in the morning on the Friday of next week, slotting in at 9 a.m.
And maybe you've gone into the details with legal representatives, but when you say first thing, do you understand that to be 9 o'clock?
Yes, 9 o'clock. The primary witness on Friday is Helen Burden, who will be taken by Mr. McIntosh. However, in order to make the best accommodation arrangements we could, we've arranged for Mr. O'Donovan to give evidence at 9, perhaps for an hour and a bit, something in that order.
Well, in that case, I look forward to see you on Tuesday. And can I wish everyone a good extended weekend?
Stand.